session is on how to complete a divorce application. Thanks for joining us, and hopefully you can get enough information out of this for you to be able to fill out your own divorce application and lodge it and go through the process and get the divorce that you are looking for. So just a little summary about Leach Legal. We've been around for 16 years and we're in the CBD. We are a specialist family law firm. Our focus is on family law and helping people to reach and getting our clients to get better outcomes through that process. The areas that we deal with children, we deal with finance, we deal with relationships, divorces, adoption and surrogacy, a whole range of different areas of family law, but that's where we play in the family law area. So this information is for you to be able to fill out your divorce application. The information that I'm giving you is not legal advice. If you have any specific questions that revolve around legal advice, I really urge you to get legal advice, and you can certainly contact us for a 15-minute discussion and get some options from there. So over to divorce. Divorce is a term I hear a lot. A lot of people ring me on a 15-minute call and say, I want to get a divorce. And the short answer to that is go on the family law website, family court website, fill out the form and get a divorce. But 9 times out of 10, actually what they're asking me is, how do I deal with parenting issues? How do I deal with financial issues? How do I unwind all of this? So people use the term divorce to cover everything that relates to a separation. When I use divorce, and particularly in this webinar, we're talking about divorce as the termination of the marriage, which is the definition that you can see, otherwise by the death of a party to the marriage. I also get people who say, I want the marriage annulled. What they're asking there is for a decree of nullity. Now, that's not a termination like a divorce is. It's a declaration that the marriage is void. I must say, I have never done one in 30 years, so they're not particularly common. But for instance, if one of the parties was already married, it could be annulled, or the decree of nullity could be made. If one of the parties or both the parties were underage, if consent was obtained by fraud or duress, mistaken identity. There's a recent case in relation to mental incapacity where the bride was so completely drugged up during the whole ceremony that she later said that she had no recollection of it and certainly couldn't freely give consent, and the marriage was then annulled. It's a decree of nullity. You can't ask for a decree of nullity if the marriage wasn't consummated, if there was family violence, if you never lived together, or if you simply just didn't get on with each other. The fact that you didn't live as a married couple doesn't mean that you can get an annulment. You can get a divorce, but you can't get an annulment unless you complete something that relates to those other decree of nullity conditions. So, divorce applications. Who can do it? Either party to the marriage can do it, or you can do it together. And can you can do it 12 months from separation. You can't do it any earlier. There is no way that you can abridge that time. So you must wait the 12 months from separation. It's effectively 12 months and 1 day. So if you separated on 3 June 2019, you can file the divorce on 4 June 2020. Why can you get a divorce? There's only one reason. So adultery or cruelty or all of those things that people talk about as grounds for divorce in this country are not grounds for divorce. There's only one, and it is that the marriage has irretrievably broken down. And the way that the court can find that it has irretrievably broken down is to have evidence before it that the parties have been separated for 12 months and that there's no likelihood of reconciliation. And what do? You do a divorce application or application for divorce. Now, in the divorce application, it will ask you about the arrangements for children. If you have no children under 18, it doesn't apply to you. If you have children under 18, the court must be satisfied that there are proper arrangements in all the circumstances made for their care, or that perhaps the divorce order should take effect even though the court's not satisfied that the arrangements have been made, but there are reasons for that. The information that you put in your divorce application is to satisfy the court as to the arrangements for the children. They do not of themselves become court orders. And I've had a lot of people come to me with their divorce application and say, well, we reached an agreement and here it is in our divorce application. That is not a court order. This is information for section 55A, so the court can be satisfied to make the orders. And we'll come, when I go through the form, I'll go through and show you the sort of detail that the court requires for that. The other important point is that children under the age of 18 years can include the family and were treated as children of the marriage. So for instance, if I'm the wife making an application by myself, and it says, do you have any children under 18? And if I have no children under 18, I could put no, but my husband's son lived with us while we were together. And so therefore he is a child of the marriage, and that needs to be included as a child of the marriage. Very important you put that in. For some people who are married for less than 2 years, they want to get a divorce. There are special rules that apply. If you apply for the divorce less than 2 years from the date you were married, you must produce a counselling certificate. So the counselling services that you go to are listed on the website, but Relationships Australia, Centrecare, Anglicare or Kinway. Once you've been to the marriage counselling, if it's not successful, you'll get a certificate of counselling, and that's what you need to file with your application for divorce. The other alternative is that you wait for 2 years from the date of marriage and then you file, and then you don't need that certificate, but you must make sure that you either have a certificate or you've waited the 2 years. So the divorce stands alone. In some countries, the divorce is part of the property settlement and the parenting arrangements. In this country, it is a separate process. It doesn't sort out your property. It doesn't sort out your parenting. Excuse me. So you've got to show the arrangements for the children, as I've discussed, but it does also commence a limitation period for property settlement, and you've got to file an application for property settlement within 12 months of the final divorce order. This is not good, is it? So what if you don't want a divorce? It's pretty difficult to dispute it. You can dispute it on the basis that you weren't separated for 12 months when the application was filed, or that you're going to get back together. But if the other party says they're not interested, then the court will still go ahead with the application. You may be able to object to it if proper arrangements aren't made for the children, but again, I've not seen that be successful. And the court can still make that order if they're satisfied about the circumstances. If the respondent objects to the divorce, the court will adjourn it off to a trial. So you'll need to file affidavit evidence and have a full trial, which could take half a day perhaps. So you would need to get really clear legal advice about whether your objection will stand. Excuse me. So why should you file? People file for a lot of different reasons. Some people file because they want to remarry, that's fine. Some people file because they want to commence the limitation period running for the property settlement, because they want to get that moving. Some people file because they don't want to be married anymore. Some people don't file because they say, why should I be the one? I didn't leave. So there's a lot of reasons around that. But really, there's two choices. You either file jointly or singly, or you wait for the other person to file. And if you file, you pay the fee, which is $930 at the moment, or $310 as a reduced fee if you have a healthcare card. But if you file jointly, you can't share the cost unless both of you have a healthcare card. There's a lot of concern around filing or not filing and how the court views that if you've got other proceedings going in the court. It doesn't really come into it. It's just simply, from a court's point of view, it's simply a procedural issue. They open a separate file and have a separate number, and it doesn't really impact anything else other than starting the limitation period running for the property settlement. Oh, I can breathe again. Awesome. So how do you apply? It's all online now. So in the old days, you could fill out your form, take it down to the family court, lodge it. Now you have to go online. The Commonwealth Courts portal, if you go to that page, you can register, and it will give you all the details to register. And then once you do that, you can go in and log in and start your divorce application. Once you lodge your divorce application, it will allocate a hearing date for you, and you will get that information. I wanted to do one online for you, but I didn't want to put my details through in case my husband found out. So I'm going to go through a form, which is the actual form that you would print off once you've filled out all your details. So that will help you to see what comes up. There are some aspects of it that might come up that I don't really know how the portal treats it. So you're just going to have to kind of have a go and see how it works out. So just going through, if you look at the application for divorce, it will ask you to check which box, which court it's in. So if you are in Western Australia, it will be the Family Court of Western Australia that you check. The little box which is court use only, just leave that, that's going to be completed. And over to part A. So if you are the applicant, then you are either the applicant as a husband or wife, or if you're going to do it together, you're the husband and wife together. They don't seem to have updated it for same-sex marriages, so I'm not quite sure how that works, but presumably you can see if there's a different form. I haven't seen one, so that's not very good. 2A, do you want to attend the hearing? Now, if you have children under 18 and you're making a sole application, you are going to need to attend the hearing. If you do it jointly or you have no children under 18, you won't need to go to court. So the wife here is making the application and she's ticked yes. And then it asks you if you need an interpreter at the hearing, and this particular person doesn't need an interpreter. Okay, so your details in part B, make sure that you get them right. It's important. This is a legal document and you need to make sure that everything matches with your marriage certificate. So complete this with your marriage certificate in front of you. Don't use the bride's copy, which is just the fancy one that everybody signs. Get one from the Registrar General that has all the details of everybody's names and occupations and all that sort of stuff. And then you can double check it against that. If there's an error on the marriage certificate, so if your date of birth is wrong, if your name's spelled incorrectly, you might need to do an affidavit to explain that. And you really should get some legal advice about that if that arises. So otherwise we have Amy and Robert, and they've got their dates of birth in. Now, Amy was born in New Zealand, which might be an issue a bit later on. And it asks you if you're born outside the date that you started living in Australia. It won't make a massive difference to your application. And if you don't remember exactly when you came here, you could just put 00002005, for instance, if you remember the year. So put your addresses in here. This is where the court is going to send stuff. So make sure you've got the correct address. If you don't have a lawyer, then you don't need to fill in the rest of the form. If you do have a lawyer, they'll be filling it out for you. So they'll put their own details in there. Make sure your numbers are correct on there in case the court needs to contact you. Now, the jurisdiction. So the court can't make a divorce order unless they have the jurisdiction to do so, or the ability to do so under the legislation. It only requires one aspect for jurisdiction to be grounded. So for instance, you can file an application for divorce if you are an Australian citizen by birth or descent. That gives you jurisdiction, and then the court can make the order. In this form, it asks you all the different jurisdictions. And again, only one person has to have one thing, but it asks you everything for both. I think the problem that might arise is at paragraph C, where Amy is an Australian citizen by grant of Australian citizenship. And I have heard that the portal requires you to upload your citizenship form certificate. So just be aware of that if it asks you for that. It's a bit tricky and it won't let you work through that until you've uploaded it. So make sure you've got that on hand. Okay, date of marriage. Again, look at your marriage certificate, make sure you've got the date right. 13 is a really tricky one if you don't know what you're looking for. Look at your marriage certificate. Generally speaking, in this culture, the male names don't change from pre-marriage to post-marriage, and often the wives change their last name. So put the name that was on the marriage certificate if it's different to the name that she uses now. Date of separation. If you don't agree on the date of separation, as long as it's more than a year, then you can put a later date in, but it's always good to try and agree on the date of separation. Did you regard the marriage as over? This is important because if you live together under the same roof during that 12-month period, you will need to provide the court with evidence that you were actually separated during that period. If that was the case with you, that can be a bit tricky. So I recommend you get some legal advice in relation to that, because there will need to be an affidavit done by an independent third party. The 2-year marriage issue is down at paragraph 29. 19. At 18, do you think it's likely that you will live together? If you click yes, the divorce is probably not going to go through. So just think about that. Now, other court cases, if you are in court on other property matters or parenting matters, it asks you about that, and you can let them know the court and the court name, and attach any orders or any documents that you have there for the court's information. Now, part F is the children, and these are the arrangements for the children. So Amy and Robert have Kira, and that's her date of birth, and she's a female, and her details are again set out at child 1. So child, mother, father, who does the child live with, wife, child's address, you click wife for address 1 and husband for address 2. And their addresses are on the front of the form. Now, these are the details for the child. It doesn't need to be 40 pages long. It just needs to tell the court that the arrangements are proper. So in this case, we talk about Kira living with Amy, spending time with Robert 5 nights per fortnight, and special days, half school holidays, payment of child support, child's in good health, child attends pre-primary, parties intend to educate her to the best of her ability. So just a summary of her arrangements. Now, if you are in the family court and you are having proceedings about parenting arrangements, and so, for instance, time and communication with the child is not determined, you could indicate, currently this is what happens, blah, blah, blah. The parties are involved in proceedings in the family court to determine the final outcome, for example, and that would be sufficient. And then, do you plan to make any changes to this? And if you do make changes to the arrangements, you will need to update the court prior to the hearing. So, for instance, if the child goes to live full-time with dad, the court should have that for their record. I'll just check that. Oh, that's just if you have more than one child, it just allows for 4 children on there. Okay, so the affidavit, if you are the applicant, so in this case, Amy is the applicant, Amy will just sign on the wife's side, and she'll need to do that before a lawyer or a justice of the peace or a notary public. So not a chemist, not a school teacher, not a policeman. Those people are not justice of the peace or lawyers. You need to choose whether you're going to swear or affirm. And then you make sure that the place of signing and the date of signing is filled in. And then if you have a lawyer, the lawyer will sign that, but you won't need to worry if you have a lawyer, because it will all be filled out for you. Okay, so you've lodged your application online, you've got a hearing date. If it's a joint application, you won't have to go to court, you won't have to do anything else. On the date of your hearing, you won't be notified. You'll need to go online onto the portal, probably the next day, because it takes some time to load up, and see if it's gone through. And then a month and 1 day later from the date of divorce, the divorce certificate will be uploaded on the portal and you'll be able to download it. It may be a few days after that, so just be patient if it's not there. If you are the sole applicant, you have a big job ahead of you, because you have to serve the application, you have to prove service, and you have to collaborate service. And then if there's children under 18, you have to attend the hearing. So as the sole applicant with children, you have a much bigger job. The whole point of this service of documents process is for the court to be satisfied that the other party knows about the divorce application. So if we simply turned up in court and said, oh yeah, we posted it out to them, and then the other side then says we never received it and we didn't have a chance to object, it wouldn't be procedural fairness. And because it is such a final thing, it is the termination of a marriage, the court needs to be satisfied that the other party knows about it and has had an opportunity to respond. So for this reason, you must serve the documents 28 days before the hearing. If it's less than 28 days, the hearing will be adjourned to allow that time to pass. If they're overseas, it's 42 days, so that's important to remember. You can't give them the divorce application unless they agree to take it. So if you say to them, look, I've got a divorce application, will you take it by email? And they say yes, and then they sign the acknowledgement and send it back to you, happy days, all good. If they say they'll accept it by email and then they don't sign the acknowledgement back, you will struggle to prove service. So the quickest, easiest and most effective way is to get somebody to serve them with the document. We use process servers, generally cost about $100. They will serve the document on the other party and they will sign a document to confirm that they've served that's acceptable to the court. If you think the other person isn't going to sign the document, provide the process server with a photo and they can then sign an affidavit to say that they gave the documents to that person. You will then need to do an affidavit of proof of identity or proof of signature. So the acknowledgement that your ex signs will have a signature on it, and you'll have to say that that's their signature because you've seen them sign it many times. If they haven't signed the affidavit of proof of signature, so the acknowledgement of service, you will need to look at the photo that the process server used and say, yes, that is the person. We just want to reassure the court that the right person has got the right documents. So if you are the lucky applicant and you're going to go to court, you get the joy of attending at the Family Court of WA. It's at 150 Terrace Road, Perth. On the portal, it will tell you which court you are in, so go to that court. You'll be waiting outside, they will call your name and you will go into the court. As the applicant, you'll stand on the right of the big table. If you're the respondent, you'll stand on the left. Court will address you. They'll ask you any questions they have. If the documents are in order, so I mean, if they've received everything, they're satisfied that the divorce should go through, they will make the divorce order. But remember, it's not final on that day. They simply make the divorce order. So the divorce order is final 1 month and 1 day from the hearing. So if the hearing was on the 1st of November, it will be final on the 2nd of December. The reason for that is that either party can appeal the divorce order in 28 days, or the parties can reconcile and they can cancel the divorce within 28 days. So that time needs to lapse. If there is some unusual circumstances, for instance, I wouldn't recommend it, but I've had people who have booked a very expensive wedding and not realised that they had to wait the 28 days. They've come to me and I've sought an abridgment of time to shorten that 28-day period so they could have their wedding. But generally suggest to people, don't book anything until your divorce at least has gone through. and you know it will be made final. Lots of people have divorce parties. I think that's great, but divorce orders don't always go through. So just be aware of that. If there's a problem with the form, if you filled it out incorrectly or the service isn't correct, it won't go through, and your divorce party might be a bit sad. So once your divorce order is final, you can remarry, and you'll have that divorce order to give to your marriage celibate. Just remember, it does invalidate your will unless it's made in contemplation of divorce. And again, it doesn't finalise your parenting or financial matters. You will need to get advice on that, and you'll need to do that separately. And that is divorces. Okay, so I've got time for some questions, about 4 minutes. Proper arrangements for the children. It's really broad. You'll see on the divorce application that I've filled out, they're really broad. So those statements that I've used are ones that I've used for a long, long time. The court just needs to know that the children are in school, that they're healthy, or that they've got health issues being attended to, that they're seeing both parents, and that they're being financially supported. So fairly broad to do that. Second question, how soon can I lodge the divorce paperwork? Do I need to wait 1 year, or can I commence the process 1 month prior? You cannot lodge your divorce application until you've been separated 1 month and 1 day. So if you lodge it, 1 year and 1 day. So if you lodge it in 11 months, when it comes to hearing, it will be dismissed and you will lose your filing fee. So you just need to wait that period out. Now, the difficulty comes sometimes when people dispute the date of separation. So one person might say, look, we separated 5 years ago, we've lived separate lives, and the other one says, no, that's not true. We only really separated when we talked about it 3 months ago. That's what the trials often are for, or people just wait for a period of time and then file it. And if you've waited the 12 months from when everybody agrees you've separated, you can always put on your form that you were of the view that separation took place several years before. The court's only interested that you've been separated for 12 months. Okay, so we've actually reached the end of our divorce process today. It's a fairly straightforward process, but it's one where I see the most errors made because it's very administrative, and so it's super important that you double check everything. I've had a client who had the divorce rejected about 3 times, and it's just been horrendous for them. So it's, as I say, it's not overly complex, but administratively it can be quite difficult. And just a quick question, can I lodge divorce paperwork while property and children settlement is still underway with a pending court date? Yes, you can. You can lodge it as long as you've been separated for 12 months. So thank you, everybody, for listening. If you want a 15-minute online phone consultation, you can go online and book, or you can call the office. And otherwise, the Family Court of Western Australia website has really comprehensive information on it as well. So you can take it from there. Great. Thanks, everybody. Bye.